information and belief. My lords, that on the face of this document means that the witness is swearing to only 16 paragraphs of the witness statement. We would submit that paragraph 17 to 32 should be struck out as not part of his witness statement. My Lord, this is a very important issue because in our view, this witness statement and the truth, the statement of truth, show that the witness statement was first crafted up to 16. And it is only after the cross-examination of Professor White and the rest that these other 16 paragraphs have been added there.
When did Dr. Professor White leave the witness box?
He left the witness box on
Wednesday.
Wednesday, yes.
Mr. Kutamba.
No, my lords, may I be permitted? No, it isn't.
Speculative.
My lords, if I may be permitted to demonstrate my point. My lords will notice that a letter was written to your lordships that I'm sure we can all take judicial notice of by counsel or solicitor for the petitioner. And if your lordships were to look at that letter, your lordships will notice that the letter was written on the 4th of February. But attached to the letter are two other letters, both dated 3rd of February, the very day that they saw the leave, and gave the impression that the witness was so sick that we needed to have...
Mr. Kotombo, how are we supposed to work with the submissions you're making? How do you corroborate them?
Excuse me?
How do you intend to corroborate the matters you're bringing up? How do we work with these submissions?
My lady, it is a fact that it was on the 13th, it was on the 3rd, that they raised these concerns about...
So your submission is that paragraph 17 upwards should be struck out. Is that your submission?
Yes, and I'm trying to explain that this is not just a typo error. It is indicative.
What you are saying is very speculative.
No.
You've made a point that the statement of truth admits only up to paragraph 16. But it is clear from the document that he has signed after paragraph 32. So whether the paragraph 17 to 32 was added after Dr. Professor White's evidence or not, it's neither here nor there. The point is that the statement of truth says that he verifies paragraph 1 to 16.
Yes.
That is the point.
Yes.
Yeah, so I think that should be it.
Very well.
My lords, unfortunately, I do have to make reference to certain comments that my learned friend made, because not only are they speculative, but with respect, they cast aspersions onto my integrity. I did indicate that there was a medical review on that day. I did give that indication, even whilst we were in court. And I indicated that I would be in contact with both the medical official as well as the witness. I believe those were clear indications, and I did that in the morning before your lordship. So for it to be suggested that somehow some things have been done, you know, I think is really not just unfortunate, but I really do not expect that we should get to this kind of death. My lords, we took the liberty of notifying them as soon as we came to court that day that this is a situation. And we gave the facts. So, my lords, I do not think that my learned friend should be entitled to make these aspersions.
We've stopped him. Yes, because we thought that when counsel on both sides maybe give concessions, the court should take it as coming from honorable men at the bar. So please, let's go on. Let's go on.
So, my lords, we were at the point of having the document adopted. He's raising an objection. Very well. Very well. Very well. So, my lords, may I respond to that objection? My lords, respectfully, that objection is without a basis. Because the witness has put his signature under the 32 paragraphs. And my lords, the witness that is actually the only place on the document where the witness has signed. Now, my lords, the witness can himself explain. And I do not wish to anticipate, but the witness can, I'm sure, explain whatever is needed to be explained in relation to this document. I do not want to provide any. I'm not going to say that.
My lords, I'm happy that counsel is saying that the witness himself can explain, which is to say he doesn't have a response to my objection. And it is not for the witness to explain at this time. The witness, but that's... No, but
Mr. Kusampo,
yes, my
if you
lady.
look at CI 87, the rules are very broad. From 3E to 3F, the rules are very broad. He does not need to be confined to his witness, even to the witness statement. So I think that you should look at the rules.
My lady, I didn't get that. You said
CI 87.
one doesn't need to be confined to the witness statement. Is that what you are
Hey, kindly look at CI 87 from 3E down. The role of the witness statement. Yes.
Yes. Yes. My lord, but our point here is that there's no good reason. There's absolutely no good reason. You can't swear to a 2-paragraph witness statement and say that you are swearing to the truth of the first 16. It shows that there's a real problem, because it's not as if he said he was swearing
So
to...
you want a ruling?
Yes, my lord.
I think the way forward, can we suggest that you apply to amend the statement of truth?
My lord, respectfully, I would have done that. I did not want to preempt, because the witness actually has drawn my attention to certain matters, not only in relation to that part, but in relation to a couple of other, where instead of 2020, it's 2021 and so on. He's drawn my attention to it, but I did not want to be the one to say that. I think, respectfully, I mean,
In evidence.
yes, my lord, the document is in evidence, but
Yes.
my lord will see that the statement of truth is not a statement that he has signed to, but it is after his signature.
Signature, yes.
And that is why I thought that, given the opportunity, the witness himself can, because as I said, my lord, I can say from the bar respectfully that he actually drew my own attention to it. I myself had not, he drew my attention to the fact that...
But as counsel, can't you just
Very well, my lord.
amend it so that we can make progress?
My lords, may I respectfully apply to have the paragraphs 1 to 16 indicated under the witness's signature to read paragraphs 1 to 32. The statement of truth is in respect of the whole of the witness statement. And the whole of the witness statement has 32 paragraphs. There's absolutely no basis for insinuations about...
The basis, Mr. Chikata, that is a document you brought to us.
Okay,
There is a basis. You know there is a basis. This is what you brought to us. So he could have let it go, but he didn't let it go. But
and let's move on.
My lords, I very well.
Paragraphs 1 to 32 inclusive. That's all.
We're most grateful, my lord.
Yes, my lords, we will pray to have certain paragraphs in the witness statement struck out. On the grounds that they are not supported by the pleadings. Also, on the further ground, my lords, we are referring to part of paragraph 4, starting prior to the so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duties she was supposed to perform in order to be able to declare a winner of the election, as she attempted to do. In the entire period after the election on 7th December, she made a couple of very brief visits to the strong room.
from line 3.
Yes, my lady.
Prior to. So prior to.
Prior to.
The end.
Yes. My lords, now, paragraph 5.
No. And your reason for contempt
Is that it is not borne out of the pleadings, my lord. Paragraph 5. We pray to be struck out as not based on the pleadings. And that's paragraph 6. We pray it should be struck out. Again, it's not borne out from the pleadings. And these are material allegations of fact that if they intended to rely on, they should have pleaded. My lords, paragraph 7 is equally not borne out of the pleadings. My lords, these are very serious material allegations of fact. And if they wish to rely upon it, they should have pleaded sin. These are basic rules. To borrow my learned counsel on the other side, they are elementary rules of pleading. My lords, again, my lords, paragraph 8. It's not based on the pleadings. And we pray that it be struck out as such. My lords, your lordship have ruled on the question of authenticity in respect of the attempt to seek originals. And our objection on that issue was that they had never in their pleadings raised issues of authenticity, which are very serious matters. But following the court's ruling, they are seeking to introduce authenticity issues through the back door. They should not be permitted to do so. Paragraph 9, my lords. My lords, may I proceed?
Can we be clear if the objection is to a part or because he's generally given us a portion of the paragraph? So just to be clear whether it's the whole or...
That paragraph can only be understood as a whole. So as a whole should go. Nothing should be left out. My lords, we again object to paragraph 10 as a material statement of fact. not found anywhere in their pleading. It is an attempt, like the earlier ones, to build a new case after the event, after the cross-examination of the first and second witness. My lords, this convenient excuse of the witness being misled is nowhere in the pleading.
To paragraph 11,
Yes,
or what?
that's not 11 I'm speaking about. Paragraph 11, where the witness claims, I admit I was misled.
So are you objecting to paragraph 11?
That is so, my
Okay, you
lady.
had not stated so. You had not stated so.
I'm sorry. We are objecting to paragraph 11 on the grounds that it is not grounded on the pleadings. My lords, it is our view that paragraph 12 should be struck out as an opinion. We don't plead opinions, we plead facts. Sorry. My lords, this is evidence. And the evidence here
Mr. Kutampa,
yes, ma'am.
you mentioned that you are objecting to 7 paragraphs out of the 32.
Never, my lords. I think
You mentioned 7.
I mentioned no number.
I'm sorry.
No, my lord.
Okay.
I said certain. Very well, my lords. My lord, paragraph 15. The portion that reads, both could not be authentic. Only by getting the originals of these documents can there be clarity on exactly which is the genuine form from the region. My lords, this is again an attempt to slip through the back door. The question of production of original documents. An attempt to which the court firmly closed its door.
Yes.
My lady, my lords, paragraph 16. Is not to be found in their pleadings. Lords, refer to paragraph 17. Lords, it is our view that it is not pleaded. It should be struck out.
Mr. Ngutuampa,
Yes.
are you saying it is not based on the pleading or the petition?
It is not
Or
based
you are
on-
not, or you are saying it is not in it? It is not based on it.
It's not based on it. My Lords, paragraph 18 raises once more the rather infamous question of authenticity and the need to produce the originals. My Lords, this whole issue of consultation, paragraph 22.
You are seeking to attack. Paragraph.
Yes, paragraph 15. My Lords, no. Part of. Yes. My Lords, I believe I've dealt with paragraph 18.
Yes, you have been recorded. Yes, you've been recorded. You are saying that he seeks to introduce the originals. The issue of authenticity. Yes, through the back door.
Yes. My Lords, paragraph 19. This is a story about making an error when he signed. And Lord, it's not based on the pleadings.
So if a man wants to say I made a mistake, he shouldn't be allowed to say it.
My Lord, this is a very, very material fact. My Lord, it's a very material fact because he had already signed the document. So if he was...
You see, it's not going to be under oath to be questioned.
My Lord, I'm saying that before we...
No, I'm asking you a question.
Yes, but before he's cross-examined, we must make sure that the evidence that is given is supported by the pleadings, insofar as it relates to material facts. Insofar as it relates to material facts. And it is our submission that this allegation is an extremely material matter, and they ought to have pleaded it. My Lords, it applies equally to paragraph 20. My lords. My lords, we pray that paragraph 22 yes.
What is the solution of paragraph?
Oh, I see. My lords, paragraph 22 is directly connected with 21. It's only a further elaboration of
Objection to
Paragraph 20.
20, yes.
20.
Yes.
the basis for the objection. I'm recording you.
My lords, any reference to this material, factual allegation? My lords, we refer to paragraph 22 and say that this is not based on their pleadings. Indeed, their pleadings refer to the letter that they wrote to the EC chair. And according to them, the EC chair ignored them or did not respond to their concerns. There's nothing in the pleading about this very important allegation of fact. If they were ready to attack He said, that to consult with the chair conveyed to her the previous day.
Seem to be relating it to
Yes.
a letter.
Yes.
But there's no relationship
No, but
to any
yes,
letter.
there's no relationship, my lord. But my point is, if they found it important a fact to plead about the letter, this serious allegation of fact should have been part of their. It's not pleaded.
Is it the there's no foundation in the pleadings, or it is
It has no basis
because
in
there's a sharp distinction between
my lords, I'm
evidence and material facts.
I'm very well aware of that.
Yes,
So I'm sorry. I'm sorry that I said it's not based on the pleadings. My lord, the paragraph 23 is equally not based on petitioners. Yes, my lord, pleading. My lord, we object to paragraph 24 for the same reason. 24, my lord, that it is not based on the pleadings. These allegations of deceit, they should have made the allegation and even given particulars of same in their pleadings, in accordance with the rules CI 47.
Is it the entire paragraph or a part of it?
No. My lord, we would pray that the entire paragraph be struck out.
And where does the paragraph talk about deceit?
The word of the chairperson of the EC.
But it doesn't say she deceived him.
But my lord, if you go into the next paragraph, it shows that the allegation is that the chairperson sent them on this.
Your submission was that it's an allegation of deceit and particulars of it should have been given
Yes.
in pleadings. And I'm saying that I don't see any reference to deceit. He said, I had no reason to doubt her word. Is that an expression that she's deceived him?
My lord, see, yet if your lordship, with respect, will refer to paragraph 29. No, but my lord, they are connected.
Unless,
My lord,
oh please, counsel, is it not a practice that if a judge is speaking, counsel should keep quiet?
well noted.
Unless you want us to read it in conjunction with the other paragraph.
Precisely.
Yes. You are not doing that.
Now, my lord, it is our submission that some of the paragraphs cannot be understood standing alone by themselves.
Yes, you are on your feet. Yes, you are on your feet.
But my lord,
Nobody will stop you.
that's precisely what I was doing.
Dr. Tampao, are you suggesting that we should read paragraph 24 together with paragraph 29?
Yes, my lord, together with paragraphs 29 and 30 and 31. It's very clear.
I think that 24 stands on its own, so anyway, go on.
Yeah. My lord, if you read these paragraphs together, the allegation is very clear that the EC chair deliberately led them on a wild goose chase in order to announce declare the results in their absence. That is the gravamen of those paragraphs. And my lords, I'm saying that these are very material allegations. And they ought to have been pleaded and the particulars of which given.
Under paragraphs 24 and 29.
That's an allegation of a state of mind, an act by the chairperson with an intent. And he ought to have given the particulars of that intent to mislead in their pleadings. My lords, if your lordships do agree with us, then it is our submission that paragraphs 25, 26, would become irrelevant and would have to be struck out as such. My lords, we've already spoken about 30 and 28.
28.
No, 29, my lords. Yeah, 20 and 29. 29 and 30, yeah. My lords, 31, in our view, follows accordingly. It's the same narrative of having been misled and how he couldn't believe that the chairperson could do that. My lords, that is all. Yes.
You mean what he can't believe is also part of your objections?
Excuse me?
What he cannot believe is also part of your objections. 31.
Yes, I'm saying that 31 is part of that set of paragraphs that are speaking to the question of deceit and being misled. A deliberate attempt to mislead them. That's... Yes. 31, my lords, reads, I can still not believe she did what she did in the light of my experience. So it's talking about what she did. That is misleading her. Him. That's the fundamental, that is the sentence. The other things are what we call adjectival clauses in English language structure. The main sentence is, I can still not believe she did what she did. That is the sentence. And then in the light is just qualifying.
Now you want to know the basis for inviting us to strike out paragraph 31.
Because, my lords, it is not based on the pleadings and partakes of the same problem that 24, 29, and 30 have. So, my lords, we accordingly pray that all these paragraphs be struck out.
Mr. Agudampa, in view of, can you correct me, agree with me if I'm right. So, apart from paragraphs 1, 2, 3, and 32, you are asking us to strike out the entire witness statement. Am I right? That those are the only paragraphs that you are not objecting to?
My lords,
No, I just want, because it's an easier way of understanding it than, yeah. Am I right?
my lord, I just want to be sure
Yeah.
that my lord, part of 15, not the whole of 15, we've indicated which part. Also part of 17 should be struck out.
So 15, which part?
15, he says the portion
Both could not. Right to the end of 15.
Okay.
Paragraph 17, my lords. From that, the portion beginning, that was one of the things to the end. I've read that already. I just choose that. Which paragraph? Huh? Which paragraph? Refer to paragraph 4, that the portion you want starts from prior to. I think I've done that.
Yes, you did.
We can.
paragraph 3 of paragraph 4, line 3 today.
Very well.
Paragraph 4, line 3 today.
I'm most grateful, Your Lordship. And paragraphs don't believe we objected to 14. Paragraph 14. We are not.
No, you didn't. You didn't.
Actually, paragraphs 1, 13, and 14
Okay.
did not attract your attack.
That's
No, 12 is included. He says, paragraph 12, opinion, not based on facts.
Lords,
Have to hurry up.
yes, we didn't take objection to paragraph 14. We didn't. We took objection to part of paragraph 15, beginning both could not be authentic. And we objected to paragraph 16. For paragraph 17, we objected to the portion that reads, that was one. Yes. And 19. Yes. Yes, my Lord. So that is our prayer, my Lords.
Yes, my lords, in support of the submissions of my learned friend, I wish to draw the court's attention to the case of Aboaba versus Additional, 1946, 12 Waka 18 at pages 19 to 20.
It has been cited in so many legal cases.
That is so, my lord. But my lords, this is what readily came to mind. With your kind permission, this is what readily came to mind on my screen. My lords, the object of pleadings is to compel the parties to define the issues upon which the case is to be contested and to prevent one party taking the other by surprise by leading evidence or material facts of which the other had no due warning. The penalty for failing to plead a material fact is the exclusion upon objection being taken of evidence to establish it, where evidence which could have been ruled out as inadmissible because it is adduced to prove a material fact which was not pleaded has nevertheless been adduced without objection and is before the judge. It goes on and says the trial judge was bound to take into consideration and the appellant ought not having raised his objection. So, my lords, it is our submission that at this key moment, the objection is timeously raised and it should be considered. My lord, the local authority that also comes to mind is Akufo-Addo versus Cataline. Yes, my lord. Yes, my lord. With respect.
That is our practice, please.
Yes, my lord, I concede. I do concede. I'm sorry, my lord.
Order in court, please.
My lords, I submit that there is no basis for striking out any of the paragraphs in the witness statement, and I will unfortunately have to go one by one, and sometimes the same point will apply, but because we're dealing with specific...
But if some of them can be lumped together and treated together, we would appreciate it, if at all possible.
Very well, I'll do my best. I'll do my best to do that. Unfortunately, each of the parts, but very well. I will do my best to avoid having to go into each of them. But my lords, if we start from the paragraph 4, which is being objected to from the second sentence, prior to her so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duty she was supposed to perform in order to be able to declare a winner of the election as she attempted to do. In the entire period after the election on 7th December 2020, she made a couple of very brief visits to...
So, Mr. Shikata, the failure to perform duty you are complaining about, is it the shortness of her visits? Is it the paucity of visits? Is that what you mean?
No, my lords, it is not the paucity of the visits. It is the content of the visits. And the witness statement addresses the content very clearly. The witness statement is very clear about that. And the witness statement it is not the paucity of the visits. I mean, the witness statement is very clear in the fact that, and if I may,
the petition. Are you referring to the petition?
No, I'm going to refer to
the witness statement.
The witness statement itself.
Their objection is that it's not borne out by the pleadings. It's not borne out from the pleadings.
Yes, but I was coming to that, but I thought you threw in a question about whether it's the brevity of the visits. And I was suggesting in response that the witness statement makes it quite clear that it is not the brevity of the visits. Because in paragraph 27, for instance, paragraph 27 is indicated, in any event, by the time we left the EC premises, the strong room verification process with the chairperson of the EC had not even begun, much less come to an end. All that had happened in the strong room was a series of informal interactions and not the process with the returning officer that is set out in the Constitutional Instrument 127. So that's just a direct response to the question that it is not the brevity of the visits that is the concern of the witness statement.
But Mr. Chikala, you see,
Yes.
I have read the petition again and again, and there's nowhere in the petition where this whole story about the strong room had been pleaded.
My Lord, my Lord, part of the problem is I was going to go paragraph by paragraph as he did.
Yes.
And then I had a question related to whether the brevity of the visits. And then, so I was going to go paragraph by paragraph in terms of the pleadings. In terms of the paragraph in the pleadings. I was going to do that.
Okay.
My Lord will see that from paragraph 6 of the amended petition of the petitioner, it is indicated as follows: purporting to declare the results, Mrs. Gina Dukwe Mensah, chairperson of first respondent, and the returning officer for the presidential election said, at the end of the transparent, fair, orderly, timely, and peaceful elections, the total. So here is a reference to her own statement about transparency, fairness, orderliness, and so on and so forth. Now, my Lord, the petitioner then goes on, after referring to the percentages and so on, the petitioner goes on, and my lords, those references, I just don't want to have to go through all the details.
Please go through them because I'm really confused.
Very well. Very well. So, after 6,
Mr. Chikata, my mind is on the testimony that she failed to perform her duty in that paragraph 4 that you are referring to. My mind is on that testimony. So you refer to paragraph 6.
Yes. I refer to paragraph 6. And in paragraph 6, my reference is to what was stated about how she made the declaration. And in paragraph 19 is a very direct statement that the first respondent and its chairperson, Mrs. Jean Adukwementa, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Then, 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Jean Adukwementa, acted in flagrant violation of the 1992 Constitution. 21, first respondent and its chairperson, Mrs. Jean Adukwementa, in the conduct of their duties, are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, candidly, and not arbitrarily or capriciously, and to comply with the requirements of law. Now, my lords, if the witness is therefore providing testimony that shows why there has not been compliance with legal requirements, if the witness is providing testimony in respect of that, that cannot be said not to be based on the pleadings. More so, where the answer of the first respondent itself puts those matters in issue. First respondent in paragraph 4 of her answer says, first respondent says further that the 7th December 2020 presidential election was regulated by the 4th Republican Constitution 1992 and the Public Election Regulations 2020 CI20. So first respondent is taking issue with the pleading, the allegation that you did not act in accordance with the Constitution and in accordance with your legal obligations. It's taking issue and says not only that they are regulated by these, the Constitution and CI 127, but goes on actually to set out in detail, which I will not get into, but sets out in detail how how the first respondent claims there was compliance. That is the whole essence of what is in paragraph 5. The whole essence of those 4 stages that she describes, particularly paragraph 5, Roman 15, and Roman 16. Paragraph 5, Roman 15, and Roman of her answer. She said, the Form 12s are then submitted to the returning officer for the presidential election, chairperson of the first respondent, at the National Collation Center. This is an answer from the first respondent as to what is required to be done. If the witness is giving testimony that shows that that did not happen, my lords, that is obviously based on the pleadings. That testimony of the witness, that what she herself is saying she was required to do, that did not happen. How can that not be based on the pleadings? And my lords, in this court, counsel for both the first respondent and the second respondent have cross-examined extensively previous witnesses as regards the compliance. They have cross-examined extensively themselves. And in their cross-examination, they sought to put it to the witnesses of the petitioner that the chairperson had acted in compliance. That's their case. And my lords, if that is their case, again, our witness is able to answer those matters that they have alluded to. So, my lords, in respect of paragraph 4, there has actually been testimony provided under cross-examination in respect of paragraph 4. So all that was read to you about additional and so on, which are well-known principles, matters have already been put in evidence. Matters have been put in evidence at the instance of both counsel for the respondents regarding what took place before the declaration. In fact, my lords, and my lords, this is really very critical. Counsel, especially for the first respondent, counsel actually put certain matters of fact to PW2, for instance, regarding that all he had testified to about leaving the premises of the Electoral Commission because they had been requested to do so was not true. And that, I mean, these were very serious matters put to the witness. What he said about the reasons why they left, the fact that they left their bags there, and I mean, they had no reason for leaving the bag. All that was stated in cross-examination to be false. All that. That was the case of the first respondent in cross-examining the witness, that everything he said was false in respect of the reason for leaving the place and so on. Well, how can it not be material in a determination of this case? How can it not be material for a witness who was there and who, in fact, if you like, played the lead role, because she's the one who went up and spoke and so on and so forth. How can his testimony about those matters on which they have already cross-examined, and they have put their case in cross-examination, and your lordships have also had reason, respectfully, to ask questions about those matters. I think your lordships asked questions in respect of Form 13. Your lordships asked questions in respect of why both of them had to go and not just one of them. I mean, evidence has been led in this court, particularly in the cross-examination of counsel for first respondent and counsel for second respondent. So, my lords, if there is testimony being offered which can corroborate the testimony, including, my lord, in that corroboration, as your lordships are well aware, in that corroboration, the witness is seeking to bring in a video recording of a representative of the second respondent in these proceedings, a video recording that he made at the time, contemporaneously, which therefore would actually give, additional third-party corroboration to the evidence that is being led. And my lords, in fact, respectfully, we were actually going to ask your lordship for that video to be played before the cross-examination. But of course, he's raised an objection, and we are dealing with that objection, after which we will do that. But my respectful submission is that where in their own cross-examination, issues of the credibility of the witness have been raised, it is really lying ill in their mouth to come now and say to this court that a witness who, by all intents and purposes, is able to provide a corroboration should have the matters of corroboration that he's swearing to, that he's sworn to in this court, they should just be struck out. My lords, that cannot, with respect, be acceptable. And my lords, while I strive to avoid going paragraph by paragraph, I'm bound to refer to some of the specific paragraphs of this witness statement. The paragraph 5, where they are also seeking to strike out, so I will take the 4 and 5 in effect together. The paragraph 5, where the witness is saying that the EC had a video documentary person recording events in the strong room. And I have no doubt that if that documentary is available in its authentic version, it will confirm what I'm saying in this witness statement about things that occurred in the strong room. So, my lord, what the witness is here saying goes directly to the issue of credibility and the availability of information, even in the custody of the first respondent, which can put the matter to rest completely in terms of the corroboration issue. So, my lords, how can it not be? I mean, so the paragraph is basically saying to this honorable court, there is a video recording that was taking place. I'm giving you my account. If you have any reason to question any part of my account of what happened, there is a video recording. So the court itself can independently even order that video recording be produced, because we have, issues of credibility arising which we want to deal with. And it is my respectful submission that there can be nothing whatsoever in a witness seeking to underline the credibility of his testimony by making reference to an independent and available source of verification.
Prosecutor, I agree with you on the principle, but this is a civil trial, and it is based on the pleadings.
Yes.
And the paragraph 5 of the witness statement, now coming to talk about a video documentary
Now I'm coming to
Talking about video documentary.
Yes.
This is the first time we are seeing this.
Yes, but my lord,
The person is not a party. Mr. Rojo Mettle is not a party, he's a witness. So his evidence must take the form of the petition. The party himself, the petition is the claim before us. So he cannot come and introduce new facts.
My lord,
that the petitioner did not even raise in the petition.
My lords, with the greatest respect,
these are material facts.
my lords,
It's taking us by surprise.
my lords, it cannot take the first respondent by surprise. Cannot take the respondent by surprise because the respondents were the ones seeking to cross-examine, contesting the accounts that had been given by other witnesses, especially PW2. They were contesting it. And what this witness is saying is that if you doubt my story, there is I observed that there was a video recording taking place. So that video recording can be resorted to by this court. Now, look, this court seeks to establish the truth of what different parties are putting before it.
The rules.
Yes, and the rules allow this court. The rules allow this court to have that independent source of corroboration to have it available. The rules certainly allow that. The rules certainly allow that. And if witnesses of the petitioner are being confronted with allegations that what they have come to this court to establish is untruthful, and there is a video, for instance, that supports them. In this case, there is a video of Mr. Mettle-Nunoo, which he is seeking to put in evidence. There is a video coming from the EC itself, the first respondent. My lord, I mean, it certainly is important for this court to consider. And my lord,
the video documentary in paragraph 5 is not what has been attached. It's not the video recording of whatever took place with Mr. Mettle-Nunoo.
I'm sorry.
Paragraph 5,
Yes.
the video documentary there is...
Yes, but PW2 also testified to that video. It's in the witness statement of PW2. He testified to that video.
So you're in essence setting up a situation where you can ask for that video then? Is that what you're doing?
My lords, we are not necessarily going to ask for that video. What we are saying, we're not necessarily, my lord, it depends on the cross-examination, because if the cross-examination, and that I believe is why it is very critical that the witness has indicated that there was that video recording, similar to what PW2 also stated. So both of them have said, we are willing to have our credibility put on the line by reference to a video that captured what happened in the same way as the video of what second respondent's representative has said. So there is already testimony before this court. And my lords, I emphasize that that testimony came in under cross-examination, challenging the account. So second witness, PW2, said there was somebody taking video documentaries and so on. That evidence was not objected to. That evidence is before you. That evidence was not objected to, it is before you. And we are respectfully submitting that what is stated in paragraph 5 is no different from evidence that is already before you about the video documentary. And all that this witness is adding is that he is willing to put his credibility on the line, so that if anybody wants to have recourse to that video, they're entitled to. Now, my lord, depending on the cross-examination, we may indeed come before your lordship with an application that that video should be produced to the court and played, depending on the cross-examination. Because, my lord, I mean, we're dealing with a situation here where matters have been put to a witness in cross-examination extensively, and he has insisted, I'm telling the truth, this and that. And he said, there was this video. This witness also comes before you and says, there is a video. What I'm going to tell you can be tested. So, my lords, respectfully, not only do we have a basis in the pleadings of both the petitioner and the respondent, particularly first respondent, as I've indicated, where they are talking in paragraph 5, Roman 15. They're saying that this is what happens at the quaternary stage. The Form 12s are then submitted. I'm sorry. The Form 12s are then submitted to the returning officer for the presidential election at the National Collation Center. And my lords will observe that that paragraph
you want counsel to address it on the paragraph 5, because you see, it appeared, both of them, from the evidence, were in the strong room.
Yes, my lord.
Yes, and if you look at the witness statement, yeah, there's nothing of this video documentary which, yeah.
No, my lord. My lord. Yes, but my lord, respectfully.
Did he say anything about that?
Yeah, PW2. PW2.
No, in the witness statement.
I'm sorry, you mean, is your lordship referring to this witness statement? Dr. Professor White gave that evidence under cross-examination after he had referred to a video. He did, there is the reference to video is in Dr. Professor White's witness statement as well. Yes, my lords, I've just been reminded that it was actually under cross-examination when he was asked about journalists being present in the room. So when PW2 yes, I clearly remember, it was counsel for the first respondent who was cross-examining PW2. And counsel for the first respondent sought to put it to him that there were journalists present in the room. In effect, there were other people who could effectively also testify to the facts. And what we are submitting respectfully is that in paragraph 5 of this witness statement, what the witness is simply doing is to indicate a basis that can be used to corroborate his testimony, arising from the video documentary that took place. And my lords will observe that the issue of the video documentary is being brought in essentially on the basis of the credibility challenge that we have seen in this court, the credibility of the witness being challenged. And that is essentially what paragraph 5 seeks to do. And it seeks to do that because the witness statement is also entitled to provide testimony to contradict the case that the other side is making. Your lordships will be aware that the case that the other side, the case that the first respondent is making, the case is essentially that they acted fairly in all respects. And in fact, in that paragraph 5, Roman 15 that I referred to, first respondent is replying to paragraph 5, 6, 7 of the petition. My lords will see that in paragraph 20 of the answer of the first respondent, paragraph 20, it says, first respondent admits paragraph 5 of the petition only to the extent that it declared results at a press conference on 9 December 2020, and that it declared the winner of the 7th December 2020 presidential election was Nana Addo Dankwa Akufo-Addo, the second respondent. And then it continues in 21 to say, first respondent in further answer to paragraphs 5, 6, 7 admits so and so. So, my lords, what I'm suggesting is that the first respondent has taken issue with the paragraphs in which the petitioner is raising issues about the first respondent's compliance with the Constitution and with the law, especially as it relates to that quaternary stage that is mentioned. First respondent is raising those issues. And if your lordships are going to be able to determine those issues, your lordships definitely want to have evidence of people who were in the room. But people are in the room and they come and they are going to tell different stories. So a witness says to you, your lordships, I was there, I saw so and so. But in addition, if you want corroboration of what I'm going to tell you, or if you want corroboration of what they are telling you, there is a video that was taken. My lords, that piece of corroborative evidence and the statement that that is available, that cannot be something that can be struck out of the witness's statement, because that's a fact. He is alleging it as a fact that there is a corroborative evidence available. My lords, after paragraph 5, we have paragraph 6. And in paragraph 6, again, this is a testimony about what happened in the strong room. That in that strong room, dedicated fax machines, printers, and computers were provided to receive faxes from fax machines at the regional collation centers in full view of agents of candidates and then projected on an overhead projector in the strong room as the results were received. Well, I mean, this is evidence that is entirely based on the pleadings, because the pleadings raise the issue of what happened in the strong room before the declaration of the results. So paragraph 6 is entirely relevant. It's based on the pleadings. And my lords, I mean, it cannot be right that the witness statement's allusion to the availability of fax machines and the fact that those fax machines were not working part of the time, and one could see the frustration on the faces of many of the dedicated fax machine EC personnel and so on. My lords, that is evidence. It is obviously not something you plead. My lords, on the one hand, when your lordships pointed out to my learned friend that the objection is being made to evidence, not pleadings, he had to concede that that is in the nature of the. But in fact, when he actually talked about each of the paragraphs, he kept saying that it is not borne out on the pleadings. In other words, he expected to see in the pleadings the statements that the witness is making in the witness statement. And that is not how the rules of evidence and the rules of procedure work. Because, my lords, there is a very clear distinction made between pleadings and evidence. There is a very clear distinction made between pleadings and evidence.
Mr. Chikata, regarding these fax machines, which pleadings relate to it? Which pleadings relate to the evidence that you want to
The pleadings that relate to it, as I indicated, are from both the petition and from the answer. From the petition, starting with that, from paragraph 19 to 21, the pleadings indicate that she was required to act to comply with the Constitution. Then 20, that she acted in flagrant violation of the 1992 Constitution, and that she had a duty to act fairly, reasonably, and candidly. And then in paragraph 23, prior to her making the said declaration, Mrs. Gina Adukwe-Mensah had been notified by agents of certain material errors.
Mr. Chikata, you see, the problem I'm finding with this, your responses is that if you look at the entire petition, from paragraph 1 to the end, nowhere did the petitioner plead. Nowhere did the petitioner plead that he even had 2 representatives in the strong room. Nowhere.
Yes, but my lord, the petitioner is not required to plead evidence in respect
but that is a fact.
No.
That is a material fact. That even as a candidate, had 2 representatives in the strong room to take care of his interests.
My lord,
they can come in now and testify and give evidence as to what they saw or what they did and what happened. But nothing in the petition indicating that even two
my lord, That is why I indicated to your lordships that in addition to what is in the petition, we have to look at what is in the answer. Because in the answer, the first respondent puts in issue the transparency and all that. The first respondent puts it in issue, as I indicated, and if she does that, the first respondent does that explicitly in paragraph 5. Now, the petitioner has to answer the case of the first respondent. The first respondent says in paragraph 5, Roman 15, starting from the beginning, the first respondent says, CI 127 sets out a 4-stage procedure for collating the presidential election results as detailed below. And this is an answer to what the petitioner is saying about acting in disregard of the law and the constitution and so on. She says, this is the process that I followed. And she says specifically what should happen in the quaternary stage. The petitioner does that.
Now, Mr. Chikata, this whole trial, I don't see any issue brought to us regarding the process of the election. What you have brought to us is your difficulty with the declaration.
My lord.
And the import of the declaration. Is that not it?
No, my lord.
All right.
That is most certainly not it. My lord, if that were all, why would we plead paragraph 19? First respondent and his chairperson, Mrs. Jinadukwe Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Why would we plead paragraph 21? First respondent and his chairperson are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, candidly, and not arbitrarily or capriciously, and to comply with the requirements of the law. Paragraph 23. Prior to her making the said purported declaration, Mrs. Jinadukwe Mensah had been notified by agents of petitioner of certain material errors in the figures collated. That's not about the declaration. That's not about the declaration. That is about material errors that have been made. And the witness statement is drawing attention. The witness statement is drawing attention to how this paragraph 23, how was the paragraph 23 actually done? Because it says prior to her making the said purported declaration, Mrs. Jinadukwe Mensah had been notified of certain material. So a witness statement which is describing how she was notified by the agents of petitioner of those material errors, that witness statement cannot be said not to be based on the pleadings, or paragraphs in that witness statement cannot be said not to be based on the pleadings. And my lords, I'm respectfully submitting also that it is not enough, it is not enough to disregard the fact that the respondents have also put forward a case which the petitioner is obliged to answer. Now, your lordship said that there is no reference to the appointment of agents and all that. And I respectfully refer your lordships to paragraphs 6 and 7 of the answer of the first respondent. The first respondent says that CI 127 provides for the candidates to appoint polling and counting agents for the various stages, and that the respective candidates in the just ended election, including the petitioner, appointed agents who represented them at all stages of the electoral process as said above. So there's a clear pleading about the appointment of agents.
Yeah, Mr. Kijikata.
The answer
It's not your pleading.
My Lord,
You build your case on your pleading.
yeah, but my Lord, respectfully, that is where I'm pointing out that it is not sufficient in determining what is an issue to refer only to the pleadings of the petitioner, because the petitioner also has to respond to the case of the first respondent. The petitioner has to respond. In paragraph 5, in paragraph 7, the answer that first respondent gives is that first respondent confirms that petitioner indeed appointed agents and stationed them at all the polling stations and collation centers, and goes on in paragraph 8 to say that petitioner's agents signed 13 of the 16 regional election results summary forms, while the agents of the second respondent signed 15 of the regional election results summary sheet. I mean, these are pleadings which the petitioner is obliged to answer through his witnesses. The witnesses of the petitioner must put the facts that are within their knowledge, which contradict some of the answers that are provided, particularly answers about what happened in the strong room. And my lords, I was referring to what is clearly provided in Order 11, Rule 7 of CI 47, which in this context, I believe, is adopted, which says that subject to this rule and rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for the claim or defense, but not the evidence by which those facts are to be proved. So, for instance, my lords, if you say the first respondent acted in flagrant violation of her responsibilities under the Constitution and under the laws which she operated under, if you make that pleading and the respondent comes and says, no, I acted entirely in compliance, and here is what I did. Here is what I did. Is it possible to cut off what's... Can you mute? Actually, it's possible to mute from. It's possible to mute from the control. So, my lords, if our pleading is that she has not acted in compliance, she says, I have acted in compliance, this is what I did, we are obliged to provide testimony that shows that it's not the case. And we don't need to provide the testimony as if we are only limited to the exact words of the pleadings. The exact words of the pleadings that we are put in are that she acted contrary to her responsibilities in respect of the conduct of the election. We say so. And your lordships, with respect, requiring us to provide the evidence of that cannot be justified, because we have a situation where not only have we pleaded that, but the respondent in answer says, I did so and so, so and so, so and so, including I had agents, and your lordships yourselves ask questions. You had agents all over the country. Your lordships asked those questions. Answers were provided to them of the respondents. All that has been in evidence clearly. So if all that has been in evidence, it cannot possibly be said that that is not an issue in this case. It cannot possibly be said that. Now, my lords, yeah. In respect of the paragraph 23 of the pleading of the petition that I referred to earlier, your lordships will note that there is not only a reference to the fact that agents of the petition, and my lord, this is again a pleading which shows that we are referring to our agents. The agents of the petitioner took certain steps. Unless your lordship is wanting us to say agents were appointed by reference to a letter dated so and so and so. But we don't need to do that, because that is evidence. But we refer to the fact that the agents of the petitioner, who have also been referred to in the answer, they notified the first respondent's chairperson of certain things. And they go on to say that she refused to accept a letter written to her raising some of those concerns. So the actions of the agents in relation to what happened before the declaration, those actions are part of our pleadings. Now, my lords, I would refer further, and we are still dealing with paragraph 6, which they object to. I will refer further to the answer.
Order, please.
The answer of first respondent in paragraphs 16 and 17. In fact, if I may start from paragraph 15, where the first respondent says, first respondent adds that during the process and as the collation proceeds from state to state, any outstanding objections are addressed, paving the way for the candidates or their agents to sign the forms where they are present and are satisfied with the resolution. Then the first respondent goes on. First respondent adds that prior to the 7th December 2020 presidential election, it put in place a system to deliver a seamless and timely collation of results, is stating that it put in place a system. And that is a system that the witness is speaking to. Part of the system. They are part of the system that is being referred to. And what the witness is doing is addressing the actual operation of the system from the 7th of December. So, my lords, it cannot possibly be something not born out of the pleadings, because their pleadings talk about. And then in paragraph 17, she says, first respondent says that numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow of the answer of the first respondent. Paragraph 17. He says, numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow for the prompt tallying and collation of the results as expected. My lords, in paragraph 6 of the witness statement, the witness is testifying to what actually happened and testifying in a manner that shows that this claim that is being made in paragraph 17 is actually not correct. It's not an accurate account of what happened in respect of the collation process. The witness's statement is directly contradicting that, because the witness's statement is referring to what happened in regard to the fax machines and their difficulties in operation. And in paragraph 7, which is also being objected to, in paragraph 7, the witness states exactly what happened, different, contradictory to what the first respondent is saying in response to the petition. The witness is saying that they say there were difficulties that were attended to in accordance with the rules. And the witness says, instead of that pre-arranged transmission system for the regional collation sheets to be transmitted to the head office of the Electoral Commission, what happened part of the time was that one of the deputy directors of the EC, that it should have been directors, but it says director. So, Dr. Sribo Kweku would from time to time bring into the strong room what was claimed to be a regional collation sheet. How he got that sheet was not disclosed. My lord, this is material testimony in response to what is stated in paragraph 17 of the answer of the first respondent. This is very material testimony. Because, my lord, it really is serious if what this witness is testifying to happened as he's describing, as compared to what is required in CI 127. Because my lords will notice, CI 127, CI 127. So, my lords, if there is an issue in this case, if there is an issue, facts about how recollation and issues raised by candidates and agents were attended to, and whether those were done in accordance with the rules governing the election, as they are claiming in paragraph 17. If there is an issue about that, with respect, the witness is entitled to give testimony that enables the court to know that what is being put before us is factually unacceptable. Now, my lords will see also that in paragraph 27 of the answer of the first respondent avers that the presidential declaration form 13, which is a tally of the 16 Form 12s transmitted without the results from the Techiman South constituency, and showing the total votes cast and the total valid votes, shows that second respondent won the 7th December 2020 election. My lords, PW2, the second petitioner's witness, stated in answer to a question from the bench that the form that was put, first of all, he said they never saw Form 30. That was his answer in earlier cross-examination. Then a question came from the bench where he was shown a so-called Form 13. And the witness stated categorically that that is not Form 13 under CI 127. That is material evidence of what happened. And my lord, that material evidence has gone in without objection. It was in answer to a question from the bench. And that material evidence shows that the first respondent's chairperson did not act in compliance with CI 127. That evidence is there on the record, and your lordships cannot turn a blind eye to a disregard of the Constitution and of the law that has come before you in evidence. Your lordships cannot turn a blind eye. And if evidence is being read, further evidence is being read, which shows the non-compliance, which we have pleaded, we've pleaded that there was a non-compliance with statutes and the Constitution and the due process provisions and so on. If further evidence is being read that shows, for instance, that Form 13 is indeed not what is provided for by law, the constitutional instrument 127. My lords, that is very material, because your lordships are obliged to ensure that the law is respected, especially when it comes to a matter such as this. And in paragraph 8, for the paragraph 8 that is being objected to, that paragraph says, my colleague Dr. Professor White and I, and that is a reference to PW1, on many occasions pointed out errors in figures and words on the sheets that were brought in, which ultimately affected totals and assigned results. This sometimes led to EC officials making phone calls on the basis of which they sought to explain and correct some of the things we pointed out. I cannot tell to whom those phone calls were made. I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. There was no transparent process in this regard. My lords, this evidence about
Mr. Chikata, would the court of law have admitted this, the last paragraph? I cannot tell if the calls were made to EC officials or some people who were also involved in collation process. This is very, very speculative.
No, my lord, it's not speculative. He said
somebody is talking on his phone.
You cannot tell.
Oh, my goodness.
Yes. But my lord, that is exactly what he said. He cannot tell.
Yes, so in the evidence, then you must as well leave it.
No, my lord, respectfully, I'm not aware of why the witness cannot say. I cannot tell to whom the calls were made, because he is saying that they pointed out errors. When they pointed out errors, some phone calls were made. He cannot tell. And he answered by saying there was no transparent process, because essentially a transparent process would have involved making it known who you are calling, because you have to make it known who you are calling so that everybody in the room is clear that your so-called corrections are coming from the right source. So, my lords, I fail to see why the witness saying, I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. I cannot see what the objection is. Is the objection being made to some other people who are also involved in collation processes? Because your lordship said this cannot be in a court of law, and I want to. And my lords will see that the paragraph ends with a clear statement: there was no transparent process in this regard. And this again is in the context of paragraph 41 of the first respondent's answer, where the first respondent is saying, in a bid to enhance transparency and public participation in the electoral process, it published all the regional election summary sheets on its website. Your lordships will also see that in paragraph 37 of the first respondent's answer, what they are claiming is that notwithstanding all the resources and trainings put in place, there is a possibility of minor discrepancies as a result of computational and mathematical errors made in the course of the collation of results. But these did not have a material effect on the overall look. That is an allegation that is being made by the first respondent. That allegation cannot just be accepted on its face as being legitimate. That allegation will have to be proved in court by testimony that those computational and mathematical errors did not have a material effect on the on the overall result. That has to be proved. And we have a witness who is coming to court and saying in paragraph 8 that we pointed out errors in figures and words that were brought in, which ultimately affected totals and assigned results.
Please, you understood me. Because you see, if you look at section 63 of the Evidence Act, it says a witness may testify to a matter without proof of personal knowledge if no objection is raised by any party. Now, the court is at a loss whether this could have been raised in evidence. That was all. We were talking of the last bit of the deposition. So that was my worry. Because if that evidence is being led in viva voce and it's not objected to, then it will go in. But then, when a legitimate objection is raised, that was why I wanted to draw the court's attention to that.
Yes, but my lord...
That is under section 63.
Yes, my lord...
No, but you've gone beyond that, so let's proceed.
The evidence has been led under cross-examination.
No, I'm talking of the witness. That's our...
Yes, I cannot... Is it... I cannot tell. Yes, my lord, and that is why I was explaining that the I cannot tell is an account of what happened when they raised objections. They raised an objection. The EC official, and we are talking about officials, these are part of the informal interactions they were having. The EC official then makes a call and then comes back and tells them something. And the witness is saying in his witness statement, I cannot tell who the calls were to. And my lord, that is a very honest, it's a very honest acknowledgement.
You don't have any power. But then it goes on. There was no transparent in this regard.
My lord,
the conclusion he seeks to draw.
yes, because, my lord, with respect,
Because there was no transparency.
Yes, there was no transparency because, my lord, respectfully, if we are dealing with certain figures, and I point out that there are certain errors in the figures that I've been provided with in sheets coming from officials. Those officials are in the room. Those officials are in the room. And they do not have answers. My lords, respectfully, I believe this is an important point. And if I may be allowed to, if I may be allowed to complete my answer, because those questions that they are raising are obviously important enough, and the people in front of them, who are EC officials, are saying to them, we're calling somebody presumably to give us the information. So they call, and then they come back with certain answers. The witness is saying, I cannot tell who they called, and to the extent that I cannot tell whether those people were even EC officials or not, it does not amount to a transparent process. But that's a legitimate piece of evidence that the witness can give. And if on that basis the witness is saying that there was no transparent process in this regard, my lord, that is perfectly legitimate. And my lord, in respect of paragraph 8, yes, in respect of that, according to my notes, that is where it was claimed that, I think it's in respect of paragraph 9. Paragraph 9. In respect of paragraph 9, I believe that is where he says that your lordships have already ruled on the question of admissibility or of authenticity. That your lordships have ruled on authenticity, and this is being introduced by the back door. No, my lords, I cannot see how this witnesses paragraph 9. I cannot see how that can be said to relate to the ruling that your lordships made, because Councillor.
Proceed, yeah.
I'm sorry. Yes. So in respect of paragraph 9, it is claimed that we are trying to introduce authenticity by the back door. Now, that is evidently not what we're trying to do, because your ruling on authenticity, your ruling on our application for the production of documents, your ruling did not say that no issues about authenticity can be raised about a document in these proceedings. Your ruling never said that. What this witness is referring to cannot be referable to that ruling. In that ruling, your lordships dealt with specific requests that we had made to the first respondent. Your ruling made reference to specific requests that we had made to first respondent. Here, the witness is speaking to specific documents that they had in the strong room. And the witness says, for instance, when we pointed out problems on the Eastern Regional Collation sheet, another one was subsequently brought in and claimed to be a corrected version. Obviously, that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. No, my lords, the witness is making a clear deduction from one set of facts to another set of facts. The witness says, we had a regional collation sheet brought before us. We challenged certain things on that regional collation sheet. Then another one was brought in, supposedly a corrected one. And the witness is saying that obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. Now, my lords, this again is clearly material evidence in support of pleadings which are challenging the claim of the first respondent.
My lords, if I, with all due respect, I think counsel should read the whole paragraph, because the sentence that follows. Yes. Very well.
My lords, the paragraph of the witness statement says, obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. The only way to establish the authenticity of that document was for the original to be made available, and a transparent process undertaken in the presence of agents of the candidates for any corrections to be effected. Now, that is the evidence of that witness. And you brought me two documents. You said one is a correction of the other. In relation to the one which was available at the Regional Collation Center, my agent was there. And my agent can give me a report of what happened. In relation to what you're saying is a corrected one, I don't know where it came from. I don't have the original. I don't have a basis to accept it. That is what this witness is pointing out in this paragraph. I will move on after. Yes.
All right.
Court is on recess now. Mr. Chikata was in the middle of defending an objection that had been raised regarding the witness statement. The witness today, Rojo Mettle-Nunoo. More than half of the about 39 paragraphs have been objected to. So we're still very much in the middle of dealing with this matter, but let me just bring you up to speed with this proceeding today, how the processes have gone. It's our election petition update here on Joy News, and it's in association with Petrosol, also DBS Roofing and Koa Mixture. So it was established at the start of this proceeding that the witness Robert Joseph Mettle-Nunoo's testimony was via video link from an unknown location. Indeed, the television sets in the courtroom showed him seated, ready to give testimony. But Mr. Akufo-Addo's lead lawyer, Koto Ampao, raised a concern bordering on the witness possibly being assisted during cross-examination in the absence of the presence of a judicial officer at the location of the witness. Mr. Chikata suggested the court could dispatch an officer at the location and assure the medical staff was on location to assist. A suggestion which was welcomed. The courts went on brief recess in order to get its official on location. Now, before cross-examination could begin following the settlement of the issue of a judicial officer on location, Mr. Ampao asked the court to delete paragraphs 17 to 32 of the witness statement, since the statement of truth only acknowledged paragraphs 1 to 16. Chikata was given the opportunity to amend the statement of truth, which he did. Mr. Koto Ampao also raised further objections, seeking to have more than half of the 32 paragraphs in the witness statement struck out. Well, there are serious material facts which should have been pleaded. This is to say that if the petitioner wanted to rely on those statements, then the petitioner should have added those statements to the original document that they filed in courts. Also, that the petitioner seeks to introduce through the back door an issue of authenticity, which the court had already dealt with, that the petitioner is attempting to build a new case after Esiedun Ketia and Kwesa White's earlier testimony. Lead lawyer for the Electoral Commission, the first respondent, Justin Amenuvo, backed Mr. Koto Ampao's objections. And for a while now, we've been watching and listening to Chachi Chikata defend those paragraphs, insisting that there was no basis for striking out any portion of the witness statement. The 7 justices have now taken a break, and we will, I guess they would return. We will continue to hear Mr. Chikata on defending why those paragraphs should not be deleted in the witness statements. Mr. Rojo Mettle-Nunoo has not been cross-examined yet. He hasn't talked about, hasn't answered any question really, apart from taking the oath. And that's where we are with this election petition update. Stay with us. We'll be back in a little bit.
Any mammy do fee, or yet more do see, and no pebiera mini best sorry, wadimu, no quadrum, on complaining that who be able to know. Sansuna me bra, we fit any, or twinging, no pejanching, the card you must say this city, there be bierano, what in dende, mea mayre, or store, no dinida, me yere, and sorry, no pa, and cassen and near her, and I said, no way and murder. Sanam papa, nifia conking, or no soon complaining that who will be any ya, or sorry, no pana, no fancy kind, or kunafu, me, acrobato, Majuma may, me can use, na me acti, na me come back, Tebiarano, a bram de bedampuna adias. Nanso men sorry dakro kranka se me hu ba bia me ya ne nyina gira se your secret awintasem e yadura e de boy ho ba ne nyina ni kowa mesha kurani e yadura onomu a ebo ni padua no e ma wo se pi usita ne yare da ho e ya nunum bi na obedia danse obenye bi ato o ba bi eton no bia na opedodo otunsu a fresh telephone number si kowa mesha abusua awintasem
nyama apemfo nkoda a woni mfie dumienu ne mma o ma nkwada no fo FDA ahwehwe ejade inkrato yi agya tumusa eye
Awesome man. And then if you are getting to watch me with Januma, you know very well said the market is booming.
Meaning I'm engine BMO. Oh, Nipen here more.
Engine BM. Boss, what's wrong with the engine?
He's not using the proper engine oil. Very selling, fair fit.
Which one? Makaza see, I've said this several times. You don't listen to me. Huh? With the chance to see Ameba. Why? Anyway, wait, J. This is the real deal. Engine oil, papa. Ever since me start to use petrol solid lubricant, my engine no more doubt is so crabby soon. Sir, I don't have any problems.
Awesome man, rim starting at tears.
Petrosol.
Petrosol Platinum Engine Oil. Quick and thick.
Passing the tape and the color and plastic and I'm what? And then no. Can you not touch with them? They are dear seal. As I can introduce DBS lifestyle gauge trusses amount. The same is a baby as a young man the day. And you know you would dance. And the crow, not sending me a benina and your papa. So DBS lifestyle gauge trusses. Yet the computer not generated. Into and I didn't go straight. And if it's a not guilty, and want to mean the enemy. A good answer after ball. Finito. More musicians saw that. More music factories, and I said, Danke, Sebiano. Me recommend DBS Trust. DBS Trust. Finito.
My beautiful wife is about to make some sweet jollof, and she uses only Lavon's tomato mix. Oh, look at that thick red paste. Quality papa. Lavon's is what makes her jollof so delicious.
This is not just jollof. This is love.
Lavon's tomato mix. Love day inside.
This advertisement has been vetted and approved.
It's time to go digital.
Create your unique online store in a few clicks. Connect your Facebook shop, Instagram, or WhatsApp business and add your products, prices, images, and stock levels. Collect payment online, offline, and in your shop. Get instant notifications of your orders and payments and deliver your product to your customer's doorstep with our delivery service. Manage your sales, customers, and staff from anywhere at any time. Get our Digipack and up to 200,000 CDs working capital to grow your business. Visit digistoreafrica.com and set up your business for free. Digistore, powered by iPay and EcoBank.
Energy is central to our very existence. Without energy, there's no power. Without power, nothing moves.
We employ more than 40,000 people, and we contribute more than 500 million taxes every month.
Has this price regulation been beneficial?
It has led to product availability.
It's rather injected highly destructive competition.
Deregulation has done the sector a lot of good.
The Energy Commission has since 2013 been implementing the energy efficiency rules.
Electric vehicle is the future of mobility.
So